email so I can just make sure that I receive and make sure that it's the exact same copy that I have on record as well.
That sounds good. Email both of us.
Bear with me, it's going very quickly through here, but unfortunately it's asking me to, it's trying to spell check everything, so I'm trying to ignore that. So you can see exactly what we have.
Okay. So has it gone out yet or not, though?
It will be out within the next few seconds. It's on its way to you now. And it should be in the docket, or the court, whatever the list of filings are anyway. So it's been filed with the court, so it should be in there.
It still hasn't come through yet, but
Yeah, it just rejected the one that went to Tara. So it's TAREREAGOR.
yeah, it's in the chat.
Yeah, that's what I sent it to, and it just came back. It says mailbox not found. So, oh, I see what I did. It's my fault. I sent something to, I typed this, had a typo. Bear with me.
It's okay. I'm gonna take a quick 2-minute break. I'll be right back.
Thank you.
Sounds good.
Okay, did you get all that stuff worked out?
Yes, it's on its way.
I don't see it yet. Let me see.
I didn't send it because I think it rejected it first, but you should both have, all three of you should have it.
Do you have it yet, Mr. Sims?
I received an email. However, there was no attachment. It was like everything was in the body of an email, and it's.
It's on its way to you as an attachment in a PDF format. It may take a couple of seconds because it's a relatively big file, but it's on its way.
Gotcha. Okay.
Has it come through yet?
Not the PDF.
All right, it's on its way. It definitely went out, and it had the last one rejected very quickly. This one didn't.
Okay, here we go. Yep, and it's an attachment. Let's see here.
It still hasn't come through for me. Did you You want to double check the email address for me?
Yeah, hold on 1 second.
I haven't.
Did you get it, Mr. Rieger?
No, not yet, Judge.
All right, I got TAREREAGOR at Yahoo. And
Mr.
M. Hoffman at Dallas.
Whoa. We're on YouTube right now, so if you could not,
Oh, okay.
not share my email address for the world.
Okay.
It's in the chat.
Oh, okay.
Hoffman at Dallas.
Okay, I got it.
Okay, yeah, it went to the proper emails.
I got it. Okay, so let me go ahead and share the screen for this so that we can. All right, Mr. Sims, you wanted to point out something in the affidavit that you thought was defective, or some things that were defective. So what?
Yes, Your Honor. So let's first start off on page 22 of the documents that he just sent. This is the alleged original contract for this matter. If you will look at that.
Can you see can you see the screen so I can?
Yes, Your Honor. Hold on just a second. I'll let you know when you're there.
Okay. Is that it now? Okay. Is this it?
There we go, right there. So, Your Honor,
good.
Correct. So this is the original contract for this matter. If you will look into the documents, it's for a 2015 Dodge Dart, and the total sale price for the vehicle was for $49,440.88.
Yes.
Also, if you will look at the top of the contract, they have a deal number and a STK number. Both of those numbers do not match the account number that the affiant in the business record affidavit testified to, or the declarant. They testified to an account number ending in 1000.
Mr. Sims, I'm sorry. Give me 1 second. Where's the account number again on this screen?
Okay, so they have a deal number at the top left of the contract. They have 71064.
Okay.
And then they have a STK number, which is F0406431.
Okay.
Okay, so that's from the original contract, and you also took notice of the total sale price, correct? The $49,440.
Okay, yeah, I do.
All right, so now if you would go back to the declaration from the affiant on page 3 of the documentation produced, the affiant testifies to an account.
Give me one second so I can. So page 3, okay, tell me what page are we looking for?
Okay, right
there.
That one right there. So if you look there, the affiant is testifying or declaring to a account number of ending in 1000. Through the documentation, we have not, I've personally looked through the documentation. I have not found any account documentation that reflects that account number.
I'm so sorry, Mr. Sims. Where does it show on the screen, the account number?
It's in bold right above Chrysler Capital. It has XXXXX1000 as the account number.
Okay, I can't see that. Let's see.
It's in paragraph number 2.
Okay, no, I see. It's just cut off on mine. Let me try this. There it is. Okay, you're right. The account number doesn't seem to match up. Okay, I see what you're talking about.
Okay, so that's my first issue. Okay. My next issue will be down on page number 8 of 43. This is the alleged transaction history.
Let me go ahead and get to that. Is this it?
Yes, Your Honor. Okay, so that is the alleged transaction history, allegedly showing the payments made on the account. Once again, none of the account numbers or the numbers on this documentation reflect any of the numbers that was from the original contract. However, this is supposed to be an alleged transaction history showing the payments made on the account. Furthermore, the first post date that they have on this document is May 3rd, 2016. And if we would go back to the original contract, which I initially did not bring up to the court, on the original contract goes back to October 31st, 2015. So that means that there is 8 months at least of transactions that the plaintiff has not provided to show transactions happening on this account. And if the transaction, the original debt amount was $49,440, and the amount in the petition which they are suing for is $11,905, the plaintiff has to show or prove how they got to that amount to prove up their damages for the case. And without a transaction history showing all the payments made on the account, it's impossible for the plaintiff to prove up their damages, or they're leaving it up to the court to try to calculate the damages for them. Both of which is not the way that the plaintiff should be entitled to a judgment in this matter. They must prove up their damages for this case.
Okay, that makes sense. What else do you have?
Lastly, Your Honor, I can go down to the calculation page, which is shown on page 29 of 43, which is the explanation of calculation of the deficiency. Now, on this document, they have an aggregate unpaid balance of the agreement on May 29, 2016, showing $31,544. Once again, Your Honor, they have not provided any documentation to show how they've gotten from the $49,440 of the original contract and how they reached the $31,544 that they're alleging in this documentation. Furthermore, Your Honor, in a case like this, specifically, let me put up some case law. Article 9 of the UCC provides that when a debtor defaults on an obligation, a secured party may take possession of the collateral, dispose of it, and apply the proceeds to help satisfy the obligations. And that's from the Texas Business Commercial Code as well. However, if the proceeds are insufficient to satisfy the obligation and the secured party wishes to obtain a deficiency judgment for the amount still owing, every aspect of the disposition of the collateral, including the method, the manner, the time, the place, and other terms, must be commercially reasonable. A creditor can meet this burden, and I'm reading from the Regional Finance versus Texas Star Motors. A creditor can meet this burden by pleading specifically that the disposition was reasonable. However, if the debtor responds in a general pleading with a specific denial, the burden shifts back to the creditor to prove the reasonableness at trial. So the defendant has made a general pleading specifying the denial of the commercial reasonableness, and the plaintiff has failed to provide any documentation showing the manner, the method, the time, or the place of the disposition of the collateral to abide by the obligations in Article 9 of the UCC for the disposition of the collateral. So given that the plaintiff has failed to provide a clear transaction history showing all the payments made on the account, given that the plaintiff has failed to completely prove up the damages for this case, and given that the plaintiff has failed to abide by Article 9 of the UCC and prove up commercial reasonableness of the disposition of the collateral in this matter, the plaintiff would like to request a take-nothing judgment in favor of the defendant, given that the plaintiff has failed to provide the foregoing.
Okay, good. Mr. Hacker?
First of all, with regards to the deal number and the which is the 71064 figure, and the stock number, which is the STK number, those are dealership inventory information on which particular car was sold. They are not the loan number when a loan was created. The dealer or the defendant obtained a loan from Chrysler Capital. It may well have been arranged at the dealership office, but the loan was through Chrysler Capital Corporation. They would have assigned their own account number to it.
Where does that show in the documentation? That
I'm looking at the exhibit that he was showing before, which was the contract, which was at page 42, I think.
Page 42, okay.
Or was it 42, Mr. Smith?
42 is this, no. So what page are you
It's
looking
the
at?
actual contract, it's the contract, which,
What page is the contract, Mr. Sims?
bear with me, I'm trying to juggle two computers and it's kind of weird. Oh, here we go. It's page 31. I'm sorry, it's not. It's
Page 22 is the original contract.
that's it, the original contract. It's
Okay. Where does it show
on the
this?
top of this page, and it's basically, hold on a second here.
This is the simple finance. This is the installment sales contract.
Right, and you'll see there's a customer number that's been whited out. There's a deal number, and on the top left of that is a stock number. That's the car in the dealership's stock. That's not the loan number that was assigned to this thing, because at the time this particular installment contract was written, it was obviously not yet on the books of the finance company, which is Chrysler.
Okay, that still doesn't answer, Mr. Hacker, that doesn't answer his question though. How do we know that this is the right deal number or this is the right loan number?
It doesn't matter, because the deal number would have been assigned to the case when it was booked by the lender. Now, he's talking about a sales price of $49,440. That's basically including everything that's on this car.
Mr. Hacker, please listen to me. Where is that in the documentation so that I can look at it?
It's on the correspondence from Chrysler on pages 32 and 34 of this over here.
Okay. It doesn't have an account number here.
Hold on a second. Let me.
I have it up on the screen, Mr. Hacker. Where is it on the screen?
And you've got this over here, which has been redacted on page 34 with the VIN number of the vehicle, which matches the VIN number in the other documentation that you have.
But there's, okay.
So that's how you could tell that's the car. Now, the price that he's quoting for the total finance includes the finance charges over the life of the loan, as is required as far as disclosures are concerned. So in other words, you might buy a car for one price, but after you finish paying it off in 3, 4, or 5, or 6 years, you're having to pay interest on that, and it would actually come out to be more money, and they do disclose the full amount over the full term.
Where is that in the documentation?
On the contract itself, it's again, page 20, the one you just looked at, 28, we're back up.
No, 20.
22. Just looking at down at the middle of that page.
Okay, where?
Where it shows the computation of federal truth in lending disclosures. It's right below the contractual price of the car.
Is it this $36,145? Is that what you're talking about? Or?
That's the original sales price of the car. That is correct. And then there's additional charges. You know, there's which brings, including finance charges, the total estimated amount of the finance charge over the life of the loan, the amount that is being financed, and then the total of payments, and the additional down payment of $1,000 added into it comes up to this $49,440 calculation. The actual amount financed is $29,000, and the actual interest rate is 17.98%, making for $19,000 and change as the finance charges on this loan. Now, obviously, that wasn't owed on a car that was repossessed before it was due, but that's how that number was calculated. The loan number would have been assigned when it was booked by Chrysler Credit or Chrysler Capital, and it reflects a 2015 Dodge Dart with this particular VIN number also on the contract. That was a new car sold by Clay Cooley Chrysler Dodge at the price shown.
So it
Now,
shows,
the
I
loan-
guess, the amount, Mr. Hacker, so it shows the amount owed is 29,000, but on the other document, it said the amount owed was 35,000, didn't it?
Well, that's calculating interest and the time frame and so forth on this. It's 18% or 17.98%. Now, this particular loan defaulted very quickly because the car was repossessed the end of April, at the end of March or early April of 2016.
So it says here aggregate unpaid balance of agreement as of 5/29/2016 was 31,544. Where does that number come from?
That comes from the amount financed, the 29,000 figure, plus interest from the date that the loan went into,
Where
was
is that
originated until
calculated?
it was defaulted.
Where is that calculation in the documentation?
It would be taken off of the truth in lending. It's basically based on $29,000 financed plus finance charges for the period of time from October 31st, 2015 until the date that the car was repossessed, which was on or about April 1 of 2016.
Mr. Hecker, where is that calculation made in the documentation?
It's calculated as is disclosed here.
There is no
It's
calculation.
$29,000, 29 whatever times 17.98% divided by 365 days times the number of days.
Where is that calculation within the documentation?
We
what
don't
you're saying
think
is not.
we don't believe there's a need to provide a exact step-by-step calculation. We are saying that this was how it was, the result calculated based upon the truth in lending documentation that was given to the defendant when he bought the car. In other words,
Mr. Hacker.
29,000 and change at 17.98% interest until paid.
Mr. Hacker, so the answer to my question, the calculation is not in the documentation.
Correct.
Is that correct?
Correct, Your Honor.
Okay. Anything else, Mr. Hacker?
Basically, yes, Your Honor, that as you can see from this particular letter that's on the screen over here, and then if you'll also go to page 32 and 34, you will find that the defendant received a letter saying that the car had in fact been repossessed.
This is page 32.
This letter over here,
This is page
that
32.
advised him that he had not made his first payment. And then if you go down the next one, 30, I think it's 32. There's a notice that the car had been repossessed. That Chrysler Capital was in possession of the vehicle, and that they were going to sell it at private sale on or before April 28th of 2016, which they in fact did. So he had been given time and an opportunity to cure the default, in which cases, if he had cured the default, he would have been able to reinstate the loan and get the car back.
Anything else, Mr. Hacker?
That's all I have right now. And then he was given the opportunity to cure the default. The car was repossessed. They sold it as they said they would, and they have sued him for the deficiency based upon the schedule of documents that you see in front of you.
Is that it, Mr. Hacker?
That's it.
Mr. Sims?
I have one last point, Your Honor, and I'll make it really, really brief. Lastly, as the bill of sale, which is page 443, which is alleging the chain of title evidence for this matter. If you look at the bill of sale, it references an Exhibit A in paragraph A. which is supposed to show an account schedule of all the accounts that was transferred from Chrysler Capital over to the plaintiff, Troy Capital LLC. However, there is no exhibit A that has been produced evidencing all the accounts that was transferred. And once again, I would like to bring up a court case, which was Jackson v. Cash. And in that case, the court stated that without any evidence that the defendant's account was attached to the assignment of the bill of sale, the plaintiff did not establish that they had acquired the account. So going back to that bill of sale, there was no Exhibit A attached, which actually referenced our client's account to evidence that it was actually one of those accounts that was transferred from Chrysler Capital over to the plaintiff, Troy Capital. Therefore, the plaintiff has completely failed to establish that they actually acquired this account in question. So that would be my last point for this matter, Your Honor.
Mr. Hacker, where's the proof of assignment in this document?
What you have is what there is, Your Honor.
All right, the court will enter judgment in the favor of defendant to take nothing judgment. Mr. Sims, go ahead and email that proposed judgment, if you haven't already, to my court coordinator, and make sure you e-file it as well. Anything else, guys?
So we have.
Your Honor.
Thank you, guys. You guys be safe out there, okay?
You
You as
too.
well.
I'll let you go
Thank you.
back to your mother-in-law. Hope she's